All right, our regularly scheduled meeting of October 19th is now in session. Would you call the roll, please?
Mayor Clark?
Here.
Mayor Pro Tem Brinkman? Here. Councilmember Cernanik?
Present.
Councilmember Cole?
Here.
Councilmember Stallman?
Here.
Councilmember Taylor?
Present.
Councilmember Trujillo?
Here. Here. Would you all rise with me for the Pledge of Allegiance, please? Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I see we have a scout troop with us tonight. Which troop are you guys? 114? And where do you meet? Oh, really? Littleton Methodist? Great. Welcome. The agenda's in front of you. Any changes to the agenda? Then it is approved as submitted. Minutes from the September 15th meeting.
I have one correction. On page two, in the motion at the top, lines 3 and 4, it was moved by Councilmember Cole and seconded by Councilmember Taylor, and then it should say to overrule the ruling of the chair.
Well, this is actually the motion that was made.
Well, actually, I would listen to the tape, and there were two ways that you phrased it. I said it that way, you rephrased it, and then when you asked us to vote, you phrased it the way that I did.
Well, Council, what's your druthers?
I guess I'll ask Peggy to go over that again because I was looking at my notes on the other page.
Okay. When I made the motion, I said that I moved to and you seconded, moved to overrule the ruling of the chair. The mayor rephrased it this way, but then when he asked us to vote on it, he phrased it the way that I had moved and you had seconded. So,
I think I second the motion is correct, but I don't see that there's a major difference in what is listed here versus the way that you stated it. The end result is the same.
I sort of agree with
well,
you.
actually, because it's a question, is the ruling of the chair the decision of the council? 1 voted yes and 6 voted no.
Yes, all of that is true. And that's when Wendy sent this to me. I looked over it. The actual wording of the question is the opposite of what the intent of the vote is. And that's why I put into the minutes me telling you all that if you voted yes on this, you would overrule the chair. I agree that it would sound a little better if it was worded the way that you worded it, but that's the way that the chair put it to the group. And so I'm trying to minimize the changes to the minutes to make them sound better when that's not what we actually did.
Well, I thought we had agreed not to do that.
That's exactly why I put it in here like this.
Okay, I'm confused by what you just said. I won't contest it if the rest of the council doesn't want to change it, but I will try in the future to make sure, at least when I state a motion, that it's restated the way I said it. So.
Okay. Any other changes? Then those minutes are approved as submitted. Minutes for October 5th.
I have 3 changes.
Okay.
On page 12,
Page what?
12.
line 345, Councilmember Cole requested in late August change from to a meeting of the audit committee. 356 on that page, add at the end of the sentence, comma, such as the museum, library, and schools. Page 13, line 399, LI3 should be GLYI or spelled out Greater Littleton Youth Initiative. That was all I had. Thank you.
I got some changes or questions, Doug. On page 7, on line 202, the citation is incorrect. The citation should be section 6-4-39 instead of 4-4.
Say that again.
On line 202, the citation should be section
Okay.
6.
Yes, I see here. Thank you. I was looking at the wrong line.
And then on page 9, $263. I think this should be 34 and or 6-4-37 because that was what was in the title of the ordinance that we adopted.
Let's look.
So 263 should be two citations there, 6-4-34 and 6-4-37. That's it.
Any other corrections?
Wendy, on page 12, line 374, it's just a spelling item. Hyundai is Hyundai.
What line?
374.
374.
HYUND.
Anything else? Then those minutes are approved with the corrections. Any new city employees?
No, sir, not tonight.
Okay. That brings us to unscheduled public appearances, which are a time for anybody to come down and ask us a question, make a statement.
Mr. Mayor, thank you. If I might, my name is Steve Anderson. Council might recall that I was here last week with Mr. Al Calusi, and we were in a study session at that time. Having given some further reflection on the study session, the topics that were discussed and progress made, it occurred to me that perhaps Council may have interest in our returning to Council for another study session to provide additional information. So I thought I would at least tender that as an offer and ask the Council and the Mayor if you'd like us to come back and visit about any further topics. It sort of struck us that perhaps some dots weren't fully connected, and there was information that may be useful in the evaluation of our efforts, I guess, to accommodate the ditch trail. So I propose if we can informationally help Council, we're glad to do so and willing to accommodate another study session.
Yeah, thank you.
You bet.
Appreciate it. Anyone else? All right, that brings us to the consent agenda, which is normally multiple items that we can approve together that are non-controversial. We can approve them with a simple motion. Tonight we only have one item, which is an ordinance on first reading authorizing an amendment to a lease. If you can read that by title, please.
This is an ordinance of the City of Littleton, Colorado, authorizing an amendment to the ground lease between South Suburban Parks and Recreation and the City of Littleton.
This is a ordinance to amend a lease. The city in 2002 purchased 2 parcels of land from Arapahoe County and leased them back or leased them to South Suburban Park and Recreation District.
And we'll pull that?
Pardon?
I want to pull that.
Okay.
Will we just go ahead and discuss it?
Yeah, let me finish doing the background then. Part of the property is where the Buck Center is located. Another part of the property is where the Sternberg Building is. The city is attempting to sell the Sternberg building, and to do that, we need to remove the parking lot from the lease that's currently leased to South Suburban Park and Rec District. This would be the first reading of the ordinance to do that. Peggy?
I just wanted, since this will come back to us, there is an error on page 3.
Okay?
It says entered into this day of September.
Yeah.
So we need to have, and I did talk with the city attorney about that, but I just figured we'd go ahead and get it corrected.
I'm glad you brought that up. Anything else?
You want that as a motion?
Please.
So I'll make the motion and then I'll amend the attachment. Is that the way you would like me to do it?
Why don't you just make the motion with the change if you want to, or you can do it separately.
See if I can
Whichever
work
way.
it in the right place. I move that the ordinance authorizing the Second Amendment to the ground lease with South Suburban Parks and Recreation be approved on first reading with the date on page 3 of attachment 1 changed from September in the first line to, it's coming back November, to November, set for public hearing on November 2nd and posted at the City Center, Bemis Library, Municipal Courthouse, and on the city's website.
Second.
Okay, it's been moved and seconded to approve the ordinance on first reading to amend the lease. Discussion. Council ready to vote?
The vote is 7 in favor. The motion's approved.
I was remiss, Mr. Anderson, if somebody on the council wants to do that, we'll make a motion. Somebody will make a motion if they choose to do that at council comments, which will be at the end of the meeting. Okay? And we can notify you of whatever the decision is.
That'd be great. Thank you very much.
Okay. Sorry, I should have said that earlier.
And Mr. Mayor, we seem to have a couple of different groups here tonight, and I suspect they're here for some reason that we might like to know about before we go or before they leave. Could we find out who these groups are? I suspect at least one group's here fulfilling some school requirement.
Well, I'm going to guess that it's Littleton High School and it's a civics class, government class, and local government. Is it? Okay.
Thank you.
Sure. Welcome.
The question is, are they looking for something controversial?
They're just looking for the mayor to sign that they were here.
Well, that brings us to item 8A, which is a ordinance on second reading enacting a change to Littleton City Code, or I'm sorry, acting a code, section 6416. If you read that by title, please.
An ordinance of the City of Littleton, Colorado, amending Section 6-4-16 of the City Code relating to failure to obey a lawful order.
You want to present that real quick?
Well, council, it says police department. Chief, who's making presentations?
Okay.
All right. Chief Coogan and Commander Christensen sent this item to you.
Awful subdued in here tonight, so let's get this place rocking.
Thank you, sir.
So, Council, we have a number of ordinances here on the agenda that we put in front of you, and this we put this together in the spirit of looking at our costs and being more efficient, which is clearly something that we've been working on this year. All of these ordinances are crimes that currently exist that we charge at the county level, which forces us to drive out to the county on Potomac. It's 26 miles round trip. It's quite a bit of mileage to drive out there and back with these charges every time. It takes an officer off the street if they're on duty, which reduces the number of officers that we have available. And if they're not on duty, then we have to pay time and a half for them to go out there. We have now hired a new judge in municipal court. We'd like to bring it to the local level so he has some oversight on what's going on, and we believe he would have a better feel for our community. So we've put these together and asked for these in discussions with the city attorney's office, the prosecutor. We felt all of these actually addressed, would be better addressed in the local court. So that's why we put these here. The first one, 8A, which is failure to obey a lawful order. We have been charging the provision of obstruction, but that requires a physical contact. This would allow us to charge someone without having to actually that there hasn't be a physical impairment on their part, an obstruction.
Questions for the chief?
Would this include things such as if a bystander is standing by and recording this on a video to be told by an officer to stop doing those things?
Well, recording isn't illegal.
No.
If they were to obstruct the scene or say this was an active crime investigation and they came into the scene and they were told that they couldn't be present there, but to record something in a public forum is not illegal.
Thank you.
Jim?
I just think there's another advantage of having these cited into municipal court instead of the county court, is when they get to county court, you don't always have a lot of control upon the timing that the case is going to be heard. Whereas I think working with our local judge, we would have, our judges, we would have a much better handle on the time if we had to take somebody off the street or if we had to bring them in for when the case would be heard. So I think that's another advantage of having in municipal court.
Well, and as you say, Councilman Taylor, which is something I failed to mention, it also forces all of our citizens to drive all the way out to Potomac and sit and wait instead of handling it here at the local level where it actually occurred. So it's quite a bit of time and distance, and the courts out there are very cramped and busy.
Bill? And Chief, on this, just trying to understand the I understand the advantages in moving the situs of dealing with it into the municipal court here. And if I catch your comments correctly, this is at the county level would be a violation. But there's in the background here, it mentions the proposed ordinance is broader and more inclusive than the state statute. And what is being made broader here than what might exist at the county level, or is this merely a parallel of the county?
This particular ordinance is not a parallel of what they have at the county. There's a statute sort of like it in the in Title 42, which is the traffic code, that has to do with the lawful order of an officer. But this particular one, you see here that we're amending our obstruction ordinance by adding a section. The state also has an obstruction section that requires the physical interference and the physical obstruction of law enforcement duties. This particular ordinance you'll see paralleled more in other municipalities. It's generally one, like you'll see it in Aurora, Denver, I think Greenwood Village has it. It is an ordinance that is geared toward that type of behavior before it becomes physical. So this particular one is more broad than what you would see in the state code. However, I can tell you it has been appealed specifically to the Arapahoe County Court, and it has been upheld with this language. So we are confident that what we're passing is constitutional and has been through the courts and withstood scrutiny.
Thank you.
Peggy?
So I do support the general purpose that you stated. throughout the several items here. But I am confused a bit about this one. Could you give me, let's say, 3 or 4 specific instances, types of instances of this?
Well, I think we tried to do that here in the example. If you look at it, we gave this example that a person refuses to comply, such as an officer's at a scene of a fire, a disturbance, or a major crime scene.
But what is it they're refusing to comply to? Obviously,
If the officer directed them to step back, we've put up evidence tape and we've said, you know, you need to step back, this is dangerous.
so we're
There's a fire in
protecting.
progress, and you've got looky-loos who are trying to get in there, and they've got their cameras going, and an officer says, you can't come in, this is dangerous, you need to step back,
Okay.
and the person
So
refuses.
it'd be real easy to put that as a specific type of thing. Could you give me a couple more?
Well, sometimes car accidents, you might have someone who's severely injured, and the fire department is trying to get them out. And again, you have people who want to get in there, and they want to take pictures, and it's inappropriate. And the officers need to say, no, you need to step back. And there may be a point of discussion about where they should be and where they're allowed to be, and it hasn't risen to the level where that person has actually physically interfered with the officer.
Okay, and can you give me a third one?
I mean, I can tell you when I was in Aurora, I saw it charged a lot in like a domestic situation where an officer would show up, the parties are still arguing, and the officer may order one of the parties away, and he says, no, I need to talk to her. And it becomes, or let's say a potential defendant slams the door in the officer's face. The officer's there to try to contact a victim in the case, and he has obstructed his ability to get in, not by physically assaulting the officer, but by refusing to then open the door to allow that contact. There's just a number of places I've seen it, and I saw it charged a lot in the domestic violence realm just because emotions were very high when officers arrive on those scenes, and when they try to separate the parties, it becomes difficult to do, especially if there's drugs or alcohol involved and people aren't thinking clearly.
So I don't have problems with those instances. I have problems with the wording here defining serious inconvenience for this subsection as meaning significant disruption to the carrying out of law enforcement commands. I have no way to know that the 3 kinds of things you just said are what is meant here. And so I'm not going to support this. I would more than welcome having this come back, as we have in several parts of code, with specific types of things delineated, called out, if you will, but I can't support it with this general thing. I think it's important for citizens to know clearly what this means.
That would be very difficult for us to define every single time in advance, and doing that would hinder our ability. And that's why it goes to the court, for the judge to determine the reasonableness of the order.
Well, I
Was the order
understand that
reasonable?
part, but it would seem to me that carrying out law enforcement commands, potentially, this could relate to something council did not approve when the Democratic Convention was coming to town, and we were asked to look at some ordinances, and we were asked to approve such things that an innocent spectator of a demonstration would not be allowed to carry an umbrella. And so if somebody ordered someone watching a peaceful demonstration to put away the umbrella, to throw away the umbrella, to get rid of the umbrella or leave, that's a law enforcement command. But the reason for it would not be clear. And so I mean, there are kinds of instances, I think, that examples could be written in so people would have a better understanding of the kind of situation that this is talking about.
Any other questions? This is a public hearing. We have a public hearing roster in front of us. There are no names on it. However, if anybody wants to come down and speak to us on this issue, now would be the time to do it. And as background for our civics class, council operates three ways. It operates by motion, by resolution, or by ordinance. All ordinances, we're required to act by ordinance on anything that basically impinges on people's freedom or costs them money, has anything to do with taxes. Is there a third category?
I'll pull out my charter.
Okay. And ordinances, we're required to go through a first and second reading. After the first reading, if it's passed by council, it has to be published so that the citizens can see what it is that we're considering. There has to be a time delay between when we pass the first one and we bring it up at the second reading. At the second reading, there has to be a public hearing so that citizens can come down and address us. If we pass it at a second reading, it then has to be republished by title, or if we've made significant changes, republished by the whole thing, and then there's a certain delay between the time it's republished, I think it's 7 days, and when it would actually go into effect. So all of these things in this agenda item A, from A through G, we passed on first reading already. We're now going through second reading on each of these individual items. So anyone want to come down and address us on this? In that case, let's get a motion and we can discuss this.
I move that the ordinance amending the Littleton City Code, Section 6-4-16, pertaining to failure to obey a lawful order be approved on second reading, and the council president be authorized to sign the ordinance. The ordinance shall be published by posting the Littleton Center, Bemis Library, and Municipal Courthouse, and on the city website.
Second.
Okay, it's been moved and seconded to approve the ordinance on second reading. Discussion. I'm a little bit in Peggy's camp. I recognize that police officers get into situations, and domestic violence is probably one of the most complex to deal with, where you have emotions running rampant and you have people doing all sorts of things. I think there needs to be some mechanism for trying to ensure that police officers can establish order at that scene. I'm a little uncomfortable with us passing a law that basically says it's illegal not to obey anything that a police officer says. That would disrupt him carrying out a command that he gives. I'm a little concerned about the broadness of it, and yet I recognize that that there are situations that you do need to get control. So.
Mayor, could I want to just emphasize, and particularly for the people that are here, something that the chief said. It's not the officer, him or herself, that makes that final determination. This means somebody could be charged with this, and that's a probable cause that the officer would make the charge. It still has to be, if somebody goes in and says, I don't think what I was given was a lawful command, Judge, it's still a judge who's going to determine whether somebody violated this. So I just want to make a sort of a careful distinction there, understand this, but it's not the officer out there who's sort of the judge, the jury, and the officer, but just so that it's a little bit clear in people's minds here. Somebody could be charged with this and still go in front of a judge and say, Judge, this is not the way it happened, and I don't think this is correct, and could be found not guilty or could have the charges dismissed. So I just wanted to make that very important distinction as to how these ordinances work.
Thank you, sir. Bruce.
Two things. I guess if I understand this all correctly, we can do this all today, and we just write them in the county. So all we're accomplishing here is the convenience and the cost effectiveness of doing it local as opposed to writing it into county. Is that legitimate?
For both ourselves and our citizens.
Right. Yeah, exactly. Okay. And then I guess the second thing is, can you chat a little bit about the training attributes of these ordinances. So when we do stuff like these ordinances specifically, how do you guys incorporate them into your training routines to make sure that the officers are up to speed on current interpretations of the law so that we're not getting a whole boatload of these things thrown out on appeal and so forth and so on?
Thank you. And actually, that's very important, because when we do make this kind of a change, we do incorporate it in the training. And as you know, we have our training days. Half of the department trains on one Wednesday and the other half on the other Wednesday. And we work with the city attorney's office and the city prosecutor on any of these and do regular legal updates, because there's constantly changes.
Right.
Both at the local level and things that happen at the state level and from the courts, and changes in the perspective. So this is something we're addressing all the time, so that the officers know that. And this change is just taking it from that county level down to the municipal level.
And how frequently on all of these are you, how frequently do the officers experience these types of situations? I mean, how many of these do you guys write in a given month?
You know, we tried to pull that out, but it's impossible to tell you with every one of these ordinances how many times it gets charged, because when it goes to court, often they plea bargain, they change the charge, they drop a charge, they add a charge. We only charge it. We don't have a way to track what changes the court might make when they examine the case. So we did try and put those numbers together on all of these so we could give you figures. We could only identify the number of times we go to the court. We can't track the charges themselves.
How, in general, ballpark, are we talking 5 times a month, 100 times a month?
Well, we put it in here, I think 451 county court subpoenas so far this year, for a total of 11,726 miles traveled, which was a total of 451 personnel hours.
Where are you reading that out of curiosity?
It's actually listed in false imprisonment in the next 8B.
Oh, sure it is. Okay.
But that's for all of these. I mean, that's for every appearance
everything,
that you
yes.
make.
Okay.
And that was because we can't tell you every single charge, what happened on every single case.
Okay.
So we did an aggregate number of what we've seen so far this year.
Okay, thank you.
Bill?
Mine's not a question, Chief, so you can relax on this one. It's a statement. I'm relying on the fact that our city attorney has indicated that this particular or wordings like this has been upheld on appeal, so we have the chance that at least the ordinance itself is solid on that side. And personally, I'm looking at the opportunity for safety and maybe a more civil approach to this, rather than asking for something to be escalated to a physical interaction to trigger something. And so my erring will be on the side of safety for our citizens, and I'm going to support this.
Peggy?
I'd like to amend
Okay.
the ordinance on page 1, section 8, and I'll read it the way I'd like it to read, I guess, or maybe I'll tell where to strike. I want pretty much to change the last 3.5 lines, and I have talked to the city attorney about this wording, and I understood her to say that she thought it was acceptable.
Peggy, are you going down the path of deleting everything after the "or"? A at the end of
Would
line
be-
34?
Well, be harm or, and then I delete 2 different chunks and substitute. So
Okay,
I
go
would
ahead.
delete 1 chunk and I would add a different wording in another place.
All right,
So
go for it.
fails to obey a lawful order or command by a peace officer, firefighter, marshal, or detention officer acting under the color of official authority, which causes or is likely to cause harm, or then strike down into line 36, ending with to cause. So the sentence would back up a teeny bit into line 34, which causes or is likely to cause harm or significant disruption to the, and then in place of line 37, disruption to the performance of law enforcement duties.
Okay. let me make sure I get this right. We are deleting at the end of line 34 the A through line 36 to the mean.
Mean to cause.
Pardon? You want to leave the mean in?
Wait a minute. Harm or we're taking out through cause and then continuing with
Through cause, okay. So we're deleting line 36, 1, 2, 3, 4, 5, 6, 7, the first 7 words through cause. We're deleting all of line 35 in this amendment and deleting the A on line 34 and changing on line 37 commands to duties.
changing all of line 37 to performance of law enforcement duties.
Performance, okay, so we're changing the carrying out to performance, carrying out of to the performance of.
Law enforcement duties.
Okay, so carrying out goes away and performance of replaces carrying out. I'll second that.
And commands are replaced by duties.
Yes, and commands are replaced by duties. I'll second that because that'll get me to the point where I need to go.
I'd like to see if the chief has a comment about the proposed change.
I think that that would still allow us to enforce what we would need to do, especially my biggest concern, as was brought up by the city attorney, domestic violence, that if we order someone to stand back to open the door to do something, I don't want that. My only concern would be who's going to define exactly what are our duties. That disturbs me that could get into an argument, but I think that addresses it still.
Okay.
Question to the city attorney on whether this language change would relate or not relate to what's been upheld on appeal.
Well, I think the definition, if I remember correctly, comes from an appeal. And so I think taking out or serious inconvenience and just substituting it with what the court says the definition of that term is probably fine. I really hadn't thought much about the duties until Chief Coogan mentioned that. I think that typically when courts look at this, they look more toward whether the officer is under the color of official authority rather than whether that's a legitimate duty or order. So provided it is interpreted that way, I'm not sure that would have much impact. I mean, I will tell you that, we don't necessarily disagree that sometimes these ordinances have difficult wording, but when we evaluate something, we have to look at what has been before the court and, to creatively come up with something of our own versus something that we know is going to withstand. From a legal perspective, we're usually going to choose something that's been upheld. And so I understand the council's frustrations, but that's why we drafted it the way that we did.
Further discussion? All right, the motion is on an amendment to change the section that we would be approving, and that takes out the A from the last end of line 34, all of line 35, and line 36 up through and including the cause. Changes carrying out from line 37 to performance and commands at the end of line 37 to duties. Council ready to vote?
The vote is 3 in favor with Councilman Cernanek, Councilman Taylor, Councilwoman Brinkman, Councilman Stallman voting no. The motion to amend fails.
Okay. Brings us back to the unaltered main motion, which is the originally submitted ordinance. Discussion on that. Council ready to vote?
The vote is 5 in favor with Councilwoman Cole and Councilman Clark voting no. the motion and the ordinance are approved.
Okay. That brings us to 8B. If you can read that by title, please.
This is an ordinance of the City of Littleton, Colorado, amending the city code with the addition of Section 6-4-41, false imprisonment.
So this looks like this is purely a replacement for an existing Colorado revised statute.
Correct.
So basically, the motivation for this is this runs it through our municipal court rather than having to drive out to Potomac.
Yes, sir.
Now, my question is, we're allocated, I believe, 5 beds out of the jail. Is that right? The city?
I don't know that.
I didn't know we had a bed
I
allocation.
don't think we have only on the juvenile issue, I believe we have a bed allocation.
There, I'm not positive, but I think there is an allocation out there, but we've never been restricted one way or the other.
Okay.
At some points, it's got too high where the sheriff will issue an order to release get his bed count down.
All right.
There's a formula out there, but we've never been.
I guess that what I'm getting at is there a cost implication for us if we were to run this through the municipal court and then decide that we needed to sentence somebody to jail? If that then caused us to go over our allocation, or are we charged by the number of people that we put in jail? And if we are, is that based on which court puts them in jail or where the offense originally took place?
We're not charged.
Yeah.
That's a county service that
Okay.
they have to provide. The sheriff can adopt some rules, and once his bed allocations go up, I think he generally asks all the municipalities to look over their prisoner list and determine whether there's anyone that can be released. I don't think it's targeted in any one municipality in the county, but they will start looking at nonviolent offenders first, and they will occasionally just release anyone. If it's a weekend and they go way up, they don't release our domestic violence offenders. They will release, someone who's there on a theft or a failure to pay or something like that before they will get to that level. So we don't pay for it. I don't think there's a formal allocation to us, and we just work with the sheriff to try to, understanding he has limitations too. We have a good relationship in trying to make sure that we don't send people that are inappropriate.
Okay. Well, I'm assuming that if it was worthy of jail, they'd go to jail regardless of whether they went through the
And I think that's the important point
county
is
court.
there would be no change in the number of people arrested for this charge. The difference would be which judge and court they would appear in for this charge.
So we're really talking a trade-off of the convenience or the cost of going out to there
Yes.
versus the added time that we add to running through our docket.
Right. The
Okay.
prisoner would still go to that jail, but the appearance would be in our court instead of the county court.
Okay.
And this particular charge is, again, a charge we see a lot on domestic violence. And some of the circumstances we see that it puts the officers in kind of a situation where they don't know where to charge is, let's say you had an assault with a false imprisonment. You'll have an officer out there at the scene trying to determine, is it worth charging this whole thing into county, or should I just charge the assault and forget about the false imprisonment? And so to not have that tool in front of them has made it difficult. And that's why when we say that some of these are initiated by the prosecutor, these are some of the reports that she's seen where, under our assault ordinance, again, we have to show injury. And so she's seen some cases where it would have been more appropriately charged as this, and the person's coming in on another charge through the municipal court. And so these are some holes that we have in our ability to handle these cases.
Okay. Questions?
So I got lost going back and forth on all this. So if we put this into municipal code, somebody would have to go out to county, to the jail and bring the person here.
The county takes care of that.
Oh, okay, yay, all righty.
Yeah.
Thanks.
Of course, that's assuming that they're jailed before the appearance.
That they haven't bonded, correct.
Right.
All right, this is also a public hearing. There are no names on the roster, but if anyone wants to come down and address us on this issue, now would be a good time to do that. All right.
I move that the ordinance amending the Littleton City Code with the addition of Section 6-4-41 pertaining to false imprisonment be approved on second reading. Council President may authorize to sign the ordinance. Ordinance shall be published by posting Littleton Center, Venus Library, Municipal Courthouse, and City website.
Second.
Okay, it's been moved and seconded to approve this ordinance on second reading. Discussion? Council ready to vote?
The vote is 7 in favor. The motion's approved.
Okay, 8C, relating to motor vehicle theft. If you can read that by title, please.
This is an ordinance of the City of Littleton, Colorado, amending the city code with the addition of 6-4-39 motor vehicle theft.
This basically makes the theft of a motor vehicle a municipal crime, and the corresponding state statute is, this mirrors what's in the corresponding state statute. So once again, we run it through the municipal court instead of the county court or,
Yes, sir. That's
district court, whichever the case may be, I guess. Questions?
And I do have a question. I'm struggling with with just one small part of this. The theft, municipal court would be involved in motor theft cases where the value of the stolen vehicle is less than $1,000, where the vehicle's not been taken for more than 24, and that's somewhat because of the state statute. Those are set differently. But the state statute says causes $500 or more property damage. So we'd be looking even at theft that's only $100 damage. Anything less than $1,000 is down to $1 even.
Are you talking,
Why damage
are you talking about the theft ordinance?
isn't relevant on the theft of the vehicle?
Well, I'm reading the document here, so that's why I'm asking on
Says
that.
the value of the stolen vehicle is less than $1,000. I'm sorry, could you show me where it says damage?
It's under E, under aggravating factors, causes $500 or more property damage.
Oh,
Then it's a felony. So on the first page, it's listing all the things that would make it a felony. And our code is saying that if we can only charge it as a misdemeanor type municipal charge if none of these aggravating factors exist.
So I was just a little confused of the different breakpoint.
these on the front are the exception when we would not charge it.
Right, I know that.
Right.
But on page 2, maybe it's a problem on page 2 of the council communication. It says that it would come under our control when the value of the stolen vehicle is less than $1,000, or the vehicle's not been taken for more than 24 hours. So why 1,000?
If it's less than 1,000, then the state code defines it as a misdemeanor.
Okay, all right. So I'm not the the attorney here or the lawyer to understand all those codes. Okay, so we're not in conflict in any way.
No.
Okay, thank you.
So, the value of the vehicle is less than the potential property damage that you cause to the vehicle, or I guess from the vehicle when you steal it. So there's two different thresholds.
Yeah, that's okay.
Okay. Any other questions? This is also a public hearing. There are no names on the roster, but if anyone wants to come down and address us, they can now. How about a motion, please?
I move that the ordinance enacting the Littleton City Code, Section 6-4-39, pertaining to motor vehicle theft, be approved on second reading, and the council president be authorized to sign the ordinance, and the ordinance shall be published by posting at the Littleton Center, Bemis Library, and the municipal courthouse and on the city's website.
Second.
Okay, it's been moved and seconded to approve the ordinance relating to motor vehicle theft. Discussion? Council ready to vote?
The vote is 7 in favor. The motion's approved.
Okay, 8D.
This is an ordinance of the City of Littleton, Colorado, amending the city code with the addition of Section 6-4-40, motor vehicle trespass.
Why don't you go ahead and explain this one, please?
I thought I'd let the city attorney do that.
This one is more of your, I guess what we maybe used to refer to as joyriding. It's also charged commonly against the passenger who's aware that the car is stolen, and so they're trespassing in the motor vehicle even though they aren't directly responsible for the theft. Under our current code, we do have a trespass ordinance that prohibits you from trespassing on real or personal property of another without permission. However, this one specifically addresses the motor vehicle, and it does correspond directly to state statute. And we believe it would be the more appropriate charge as motor vehicle trespass, although not classified differently as a crime, is put in differently at the Colorado Bureau of Investigation, and it helps better track whether there's a pattern of motor vehicle theft or whether it's simply a trespass, because trespasses can have many different levels. A trespass can be as simple as not checking in at the school. When you go into a school building that requires you to check in at the office, you could be charged with trespass for something like that versus a trespass where you're in a stolen vehicle, which I think would be considered an aggravating circumstance. So this would be more appropriate for that type of charge.
Questions?
Well, I'll ask city attorney. So I talked to you on first reading on this, and I called you again this morning, and I understood you both times to say we don't really need it.
No, we have a tool to charge it.
Right, so we don't really need it. To me, this complicates the concept of our code. So, based on your saying we don't really need it, I prefer not to do it. So, thank you.
Further questions? Jim?
I guess I just make the comment that sometimes I think when the officers are on the street, if they've got all of their citations in a single category that they can look up more easily without having to search for where something else may be in their code list, that having it along with everything else would be beneficial.
Okay, this is a public hearing. I'm assuming there are no names on the roster. If there's, oh, that's okay. It's a pretty safe assumption.
Way to go, Bill.
If there's anybody that wants to come down and address us on this issue, though, now would be the time. Okay, let's make a motion. We can discuss it.
I move that the, you want it?
No, go, Bruce.
Oh, okay. I move that the ordinance adding section 6-4-40 pertaining to motor vehicle trespass be approved on second reading, and the council president be authorized to sign the ordinance, and the ordinance shall be published by posting at the Littleton Center, Bemis Library, the municipal courthouse, and on the city website.
Second.
Okay, it's been moved and seconded to approve the ordinance creating an offense of motor vehicle trespass for the city code. I don't have a problem putting a specific charge of motor vehicle trespass in the city code, because if law enforcement needs an ability to keep track of it, I'm okay with that. My problem is with the wording of this particular ordinance. If we took trespass, the regular trespass ordinance, and slapped motor vehicles on it and made that as a separate charge so that it could be kept track of, I could pass that. But I'm having a hard time passing a law that says it's unlawful to unlawfully get into a motor vehicle, because that then makes it completely unknown when you're in the vehicle unlawfully, whereas our trespass defines that. And while I realize that lawyers work the law through the justice system and there are appeals and there's ways of doing it, the whole reason why we have laws is to describe to the citizens what is lawful behavior and unlawful behavior, and they're actually the most important participants in the whole process. Our laws should be clear and understandable of what is appropriate behavior and what isn't appropriate behavior, which is also the reason why I had the problem with 8A. So I can't pass this as it is right now. If you've got the trespass handy and want to suggest an alternative, then I would move to amend it to that, and if we got the motions and that passed, I could vote for it. But I can't vote for it in the form that it is right now. But I can support putting one specific for motor vehicles. I just can't live with the language that's in this particular one. And I'm sorry, I don't have the trespass with me tonight.
You want to know the number?
I know the number, but I don't know the actual language.
I have that too.
Do you?
Yeah, I read it at what I read at the last meeting. Do you want me to read that?
No, why don't you give it to me? I don't think I'll be able to read that one.
Yes, you can't read that? You can read that.
You know, rather than do that, I'm going to move that we postpone 8D to November 2nd.
I'll second it.
Okay. It's been moved and seconded to postpone 8D to November 2nd. Discussion on the date. Council ready to vote on the postponement?
The vote is 5 in favor with Councilman Taylor and Councilwoman Brinkman voting no. The motion to postpone is approved.
Okay. This allows me to get a written version of this to everybody so you can see in advance rather than trying to do this here.
Question for clarification on that. If it gets modified, does that mean it has to go through the entire process again?
Well, we can do it by amendment.
It'll have to be republished in full.
Right. But, Mayor, I can just send you some language,
Okay.
and you can look it over and see if that's what your amendment would look
Yeah,
like.
if you want to just take the trespass, because I remember reading that earlier
Right.
today, and I should have brought that with me, and then just make that specific to motor vehicles, then that would make me
Sure.
happy.
Okay.
Because that defines, to me, it makes it clear when you can and can't be in the vehicle.
Okay.
Okay, 8E. You can read that by title.
This is an ordinance of the City of Littleton, Colorado, amending the city code with the addition of Section 6-4-43 relating to violation of a court order. And this one did come out of our office, and I believe that the prosecutor worked with the new municipal court judges on this ordinance. We do have the ability to put no contact orders into place on domestic violence cases. However, we did not have a mechanism by which we enforced those orders through the municipal court. And domestic violence cases, the cases themselves have a mandatory arrest, and any violation of a restraining order or no contact order also has a mandatory arrest. So these were all cases that were resulting in charges, and all those charges were having to be filed into the county court.
So you either had to separate the charges or run them all through county court?
Yeah, we didn't have any. The only way we could handle it in municipal court was through a contempt citation, and that wasn't something that an officer can arrest on because a court has to issue a contempt citation. So what would have to happen is the officer still has to make the mandatory arrest because it's required in the statute. They have to charge them into county court for a violation of a no contact order, which gets procedurally a little messy because it's not an order of the county court. It's the county court now enforcing an order of the municipal court. And so then they refer it back to the municipal court for a contempt order, but that takes a couple of weeks to get the contempt order out, and it just was procedurally not very efficient. And so to have our own ordinance where we could enforce that, we could book them on that and have them arraigned next day, which is also very important in our domestic violence case filings. We try to fast track every one of those cases through the court so that we have next day arraignments and we get them adjudicated in a relatively quick manner. And so this is another tool that allows us to continue to follow up. And these can happen after a case is adjudicated. They can happen in the middle before anybody's even been to trial. No contact orders typically go into place the day of the arraignment. And so this would allow us that extra tool.
Okay, questions?
Just in taking a look at the suggested motion, it just mentions quite simply a court order when indeed it's no contact orders. And so the way we'd go is with the specific ordinance wording that's attached.
Right, because the ordinance refers to section 14-4-101, which is specific to domestic abuse orders. And so if there were some other kind of order from the court, for instance, the court orders someone to do community service, you couldn't charge them with failing to obey a court order under this. They would go back into the contempt or failing to abide by the sentence. But this particular ordinance could only be used for those kinds of orders.
Thank you.
Okay, this is a public hearing. There are no names on the roster, but if anyone wants to come down and address us now. Judge Anderson.
Good evening. In this particular proposed ordinance, obviously the court has a vested interest in this. There's been some mention about the inherent authority that the court has to issue a contempt citation, but the difficulty that we have with enforcement of our court orders, particularly municipal protection orders, no contact orders, and the like, is exactly what's been mentioned here, that trying to get our orders enforced by a different tribunal makes it difficult and eliminates the local enforceability of the orders that we issue in our court. So I am going to encourage the council to approve this particular ordinance here so that we will have the ability to enforce our local orders. I think I looked at 14.4.101, and I am not sure that that is a still active state statute. I know that it was, but I know that the state a few years past had gone to reorganizing enforcement of what was then called restraining orders, now as protection orders, and that may be a section that we need to double check the reference to. But I think that the purpose of this is trying to get those particular type of orders in domestic violence cases enforceable in our local court. And because the way the contempt works, it's something that's brought either direct contempt, something that the court, which is me or my staff, directly sees in court, or an indirect contempt, which would be the type that was being referred to here, are very difficult procedurally to handle and to prosecute. This would give us the ability to do that by municipal ordinance violation and by charging it as such. So, and the idea of this is that once somebody comes into court, be they in custody or not, I issue, or one of the other judges issues a protection order or no contact order in the case, notifies them of that, and we serve them with a copy of that order. The most common circumstance is that they violate it by going back and having contact with that protected person in violation of the order because they simply cannot stay away from that person in a traditional domestic violence situation. Causes risk of harm, and many times because of the cycle of violence that goes on, the protected person often is either coerced or falls back into wanting to allow that person to have such contact. If that happens, it creates a dangerous situation for them, for other family members, including children, if that type of contact is allowed to happen. So this is something that I feel very strongly the council needs to look at and favorably handle so that we can have that protection of our community and enforcement of the orders that we issue for protection of individuals in these type of cases. And the only thing I'd want to do is look at that section, make sure
Yeah,
we
I think if council could just add after the reference to 101, just if someone could amend to put et sec, which is ET period, SEQ period, that will incorporate the entire section of domestic abuse, and then we won't have to worry about what 101 specifically says.
So I'm sorry, you're saying
So after
line
10
28?
yeah, line 28 after 14.4.101, just put a comma, ET period, SEQ period.
ET period, SEQ period?
Yeah,
Oh, because everybody knows what that means.
et sec. Yeah. Means the whole,
and following.
right.
If we put "and following," would it cause anybody heartburn?
Well, it won't be the legal.
Not the way that we usually do it in the law, Mayor, but I think the purpose of that is if you have multiple sections, some of which apply, some of which follow directly after 14.4.101, 102, 103, something like that, it'll bring all of those within the section. That is the domestic violence area within state statutes. So it would pick up all of those.
But do we really, I mean, and I hate to be anal about this, but do we really expect our citizens to know Latin in order to be able to?
I don't know
Didn't
that
take
that
Latin.
would be
Actually, I
expected,
did.
but at the same time, it's traditional. I think it probably appears other places within the municipal ordinances, anytime we refer to a large number of statutes.
Okay. I have a question about the communication where it says the person commits a crime of violation of a protection order if they've been served with the order or if they've otherwise acquired knowledge from the court or law enforcement personnel of the actual contents of a protection order. So explain to me how that works.
Well, if we have somebody that gets arrested and are jailed, we do a video advisement where they're in the Arapahoe County Jail and we're in the Littleton Courthouse. We will issue the order, but we can't physically serve it on them like we would if they had bonded out and appeared in court where they would receive a copy directly. But they'll be notified of the contents, and usually I'll read the entire order to them so that they're aware of what they can and cannot do. I'll also advise them that only the court can change it, not the victim and not the police, so that they don't fall into the trap of saying, well, they told me it was okay to come over and talk to them, they usually being the victim. So if that's a case where they can't physically receive a copy of the order at that time and wouldn't get it until maybe they came into court at a later date, if they still had knowledge of the contents of the order, they got released, bonded out, and then went directly over and violated the order, it would prevent them from falling into a loophole here where they say, well, I never actually got the order, I couldn't read it over and see what I was supposed to do.
So if they violate it, then do you provide the tape to the court when they're convicted of violating it, or?
That would be a matter of evidence that the prosecutor would need to provide to the court as part of the prosecution. That would show showing of knowledge.
Okay. Questions? Any more questions? Thank you, Judge. This is also a public hearing. There are no names on this roster. If anyone wants to come down and speak to us on this issue, now would be the time.
The judge was not part of the official public hearing.
Pardon?
The judge was not part of the official public hearing.
Did
He
I
came
already
down when you asked that, so.
Did I already say that?
You opened that public hearing
Made
at
the
All right.
8:04.
I'm second call. Anybody want to come down?
Mr. Chairman, I move that the ordinance amending the Littleton City Code with the addition of Section 6-4-43 pertaining to violation of a court order, with the addition on line 28, after reference to CRS Section 14-4-10, add comma,
Dash 101.
Dash 101.
dash 101, thank you, add comma, ET period, SEQ period. That as that is changed, it be approved on second reading, and the council president be authorized to sign the ordinance, and the ordinance shall be published by posting at the Littleton Center, Bemis Library, the municipal courthouse, and on the city's website.
Second.
Okay, it's been moved and seconded to approve the ordinance, changing it, adding the fancy Latin on line 28. Does Discussion? Council ready to vote?
Sorry about that.
Vote is 7 in favor. The motion's approved.
Okay. That brings us to 8F, which is an ordinance for reckless endangerment. If you can read that by title, please.
This is an ordinance of the City of Littleton, Colorado, amending the city code with the addition of Section 6-4-42, reckless endangerment.
This again, sir, is copying the state statute.
Okay, and this is reckless endangerment is when a person engages in conduct which creates a substantial risk of serious bodily injury, but doesn't actually do the injury itself.
Correct.
And we're back to the reasons of citing us into municipal court rather than going back out to, since this mirrors what already exists in Colorado revised statutes.
Correct.
Okay. Questions? This is a public hearing. You can come down and address us now if you wish on this issue. All right, how about a motion, please?
I move that the ordinance amending the Littleton City Code with the addition of Section 6-4-42 pertaining to reckless endangerment be approved on second reading, and the council president be authorized to sign the ordinance, and the ordinance be published by posting at the Littleton Center, Bemis Library, Municipal Courthouse, and on the city website.
Second.
I'm glad you changed that, because if I sang
Yeah.
the ordinance, it would not be pretty. Discussion? Council ready to vote?
The vote is 7 in favor. The motion and the ordinance are approved.
Okay, 8G, we're on a roll. If you can read that by title.
This is an ordinance of the City of Littleton, Colorado, amending the city code with the addition of a new subsection to 6-4-34, possession of cannabis definition.
So this ordinance is to recoup the sum of the cost for the destruction of marijuana that is taken in evidence. We've previously been destroying it at DIA, and that incinerator is going away, and so there is a cost to us for destroying the illegal drugs.
Bruce?
Help me understand, is this more or less a direct cost? I mean, is somebody charging us $25 to actually conduct the destruction?
Let Commander Christensen speak to that.
You know, on an average, year to year, we spend about $2,000 a year. It depends on how much we have to take out. We coordinate it with other departments so that everybody gets together, at least 2 or 3 agencies.
Okay.
So then we pay them a set fee to use the incinerator.
But presumably there's elements of an overhead cost associated on your guys' part for, you know, having to process the stuff, do the paperwork,
There's a
make the
pretty-
arrangements.
Yeah, there's a pretty comprehensive thing we go through before we can destroy any drugs. It has to be all reweighed and certified, and there's about 4 or 5 people involved to make sure that what we said we took in was so many grams. This is what we're getting rid of. It's all certified, and then it's all.
So, I mean, is there any it wouldn't be unreasonable in your opinion to try to recoup some of that cost necessarily as well, in addition to the direct cost of the destruction, right?
Oh, that's true.
Okay.
At this point, we don't know where the destruction's going to go. There's some discussion in some of the agencies involved, the South Metro Drug Task Force, to maybe buy a portable incinerator that can be shared between agencies, that we could drive to each other's agencies on a trailer or something like that. So we're not sure where we're going, how we're going to get rid of drugs in the future. But there's some discussion out there.
Okay. I guess without trying to co-opt this thing, I'd be potentially interested and could make a motion to maybe postpone this one to November 2nd as well, to see if you could come back with a more comprehensive cost estimate of the full cost as opposed to just the direct on this, and see if it'd be appropriate to recoup more.
I thought you were going to ask to bid it out to the dispensaries.
Hadn't thought of that.
This isn't just cannabis.
All right, it's been moved to postpone this to November 2nd,
Second.
and moved and seconded to postpone this to November 2nd. Discussion on the date.
I have a question. He gave specific reason for postponing. Is that not going to be part of the motion?
No.
Would we need a separate motion to clarify the purpose?
No.
So we're just postponing.
Yes. Discussion?
I think you guys okay, I'm good with it.
Makes the typing less.
Heck of a discussion.
Yeah.
The vote is 5 in favor with Councilman Taylor and Councilman Trujillo voting no. The motion to postpone is approved.
Okay. Thank you.
Thank you, council.
That brings us to reports. Mr. City Manager.
The only thing, Council, I have is to remind you that you have breakfast this Thursday morning with, and it's going to be a little different format this year. This is with Dr. Diana Doyle, who's the new president at Arapahoe Community College. In past years, the college president has brought several members of the college administration, but Marlene talked to Dr. Doyle this morning, and she wants to present a PowerPoint, kind of an overview, a presentation about the status of the college. So it'll be, I don't know that all of you have had a chance to meet her, but it'll just be Dr. Doyle, and she's got a presentation she'd like to present, and then we'll have chance for discussion, open discussion, and any questions. So, but
Okay.
just to remind you, 7:30 Thursday morning, breakfast next door, and we'll be hosting Dr. Doyle from ACC. And that's all I have.
I don't have anything.
Dr. Cole.
I have two questions. One relates to the status of my request several months ago, maybe 6 or more months ago, to get the city name added to the city parks that now have signs that say only South Suburban's name on them. So I don't want that to fall off our radar, please. And my second item relates to what some people somewhat affectionately refer to as the Fremont Freeway. There still seemed to be quite a bit of citizen concern about the speeding of they and first students, but who knows, on their way to and from Heritage. And I'm just wondering, is there not some other assistance we can give by doing something? And I don't know what. I'm just asking that maybe the various great thinkers on staff can think of a way that is going to discourage students or whoever from speeding on that street.
I can certainly go back and ask the staff. Dr. Cole, I think Heritage has been there since 1971. We've probably had a request to do something on speeding on Fremont every year since 1971. In my 26 years here, we've probably written, I would say, at least 20 staff memos, speed bumps. We've done enforced. We've done saturation.
Yeah,
enforcement.
I know all the efforts. It's wonderful
Yes,
what we've tried.
And we've actually, at one year, we actually reported, this is a little anecdote. We did, at the start of school, we did about 3 days of saturation enforcement. And I actually asked then, because we had, in those days, we'd gone over to the cafeteria at Heritage and had a meeting and talked with the folks. So I actually had the police department, I think we wrote something like 50 or 60 tickets in those 3 days, and I asked for a breakdown because we get the ages on the tickets. As I recall, I believe around 58 to 59% of them were adults over the age of 21. And so it's, I know the sort of the mantra is it's always the kids, but in that instance, there happened to be a lot of adults who perhaps were in a hurry to drop their kids at Moody or something like that, or Damon Runyon. But we can certainly go back to the drawing board. The police have been down there. We've done extensive, we've actually, I think 1 year, we issued radar guns to some of the residents. But you know, maybe there's always a new mousetrap, and we can, I'll get with the traffic division and police and see if there's some new creative ideas that we might.
Well, and I know we have these concerns around several of the schools. It's just
Yes,
that
ma'am. Mm-hmm.
more recently I've been getting the comments more from there, and I know we've tried many, many things. When I've been out in that area, some people ask for more speed bumps. Some people say, take the darn things out, and they use
Yes, ma'am.
different
Some
words.
people love them, some detest them.
And
So
you know, and then on my way here tonight, you know, I'm coming down Littleton Boulevard, and of course we've got the speed light there.
Yes,
and
ma'am.
I'm wondering maybe something, because Charlie Boston said people see that and they slow down, you know. So I don't know if just having something like that would
Sure.
slow them down. I don't know.
we've got those movable signs. I mean, we can certainly maybe experiment a little bit more. And the staff is, like I said, we're happy to try anything that's a sort of a new wrinkle. So I have senior staff tomorrow. I have Mr. Bloston and Chief Coogan there, and I can certainly bring it up with them, and we'll re-brainstorm it.
I appreciate that.
Sure.
And if anybody happens to be watching out in TV land, I encourage you to exercise your right to vote. Just really important in a democracy. Thank you.
You're not going to encourage them to exercise their right to break on Fremont? Jim?
Peggy, I want to respond to your first concern about having the city named to the city park sign. It was my experience when I served on the South Suburban Board that they normally hold those in reserve till the sign needs to be replaced because of the cost of doing things like that. And so it could be on their radar screen already, but until they start replacing those signs, it probably is not going to occur.
I thought Mr. Bloston had responded to that, Dr. Cole, but I'll just have to check with him. You track that very closely, so.
Well, and I may be wrong on that.
But let me double check. I will see him tomorrow again at staff, so we'll follow up and find out. I had the impression he responded, but apparently not. But
Yeah,
we'll get
and
you an answer for sure.
So in response to that, I appreciate what you just said, Jim. I think if nothing else, there might be some kind of decal or whatever that can get put on. It saddens me every time and I do it often, walk and jog around Stern Park, that there's no indication that belongs to the city of Littleton, and that's true of many other parks in the city. So I think it's good for the citizens to know that there are parks. Thank you.
Bill?
Yes. First, congratulations to Lisa Champ, who has very recently been identified as one of the auto industry's 100 leading women. It's nice to have local folks recognized on a national scale. Also, for folks to note on their calendar, particularly those folks that may have a background that can be applied in the clean energy area, there is a Green Career Resource Fair that's being held this Saturday at the ACC from 9 to 2. And if folks are looking for additional information, you can go to coloradogreenjobsfair.com. For this Saturday, there'll be over 20 companies that will be represented. It's interesting, given some of our other discussions with the South Metro Denver Chamber of Commerce, as on November 4th, which is the Thursday after the election day, it closes, that there is a legal lunch series on succession planning. Also a recognition by the South Metro Denver Chamber with regard to participation in the area of the Clean Tech open. This past year, there were 50 applicants across the 6-state Rocky Mountain region. 3 finalists were identified out of 15 semifinalists, and the 3 finalists will be attending the national awards to be made in San Jose in November. And also, the South Metro Denver will be having their Business Expo on Friday, October 29th, where local businesses will be represented as well. With regard to the South Suburban Park and Rec District, they're in the midst of their final public hearings on their budget for 2011. Roughly, there's been about $280,000 of fees given utilization at 2010 levels. These would represent that number. And also at their last meeting, they're proceeding with analysis on refinancing their COPS, and also they extended an appreciation on the South Platte Park project approval that came from this council. And also they did approve the effort with the Corps of Engineers to do the hydro analytics on South Platte, on the South Platte River. The Historic Preservation Board met last evening. They did discuss their grant program for 2011, given the budget constraints, and are emphasizing facade grants, possibly in 3 levels, but meant to be full utilizations. And that's somewhat a move away from their prior grants that also looked at maintenance activities. And there has been an amount of progress on the design guidelines, as there was a workshop and the consultant is currently pulling that information together, particularly for the historic district. Thank you.
Jim.
Yes, Littleton Housing Authority, all of you get the monthly report, and so I'm not going to repeat things that will be showing up in that, but I will say that there was a new law that was passed recently that caused all the rehab loans to now have to go through a mortgage banker, a mortgage broker, excuse me. It's certainly going to slow down our process of being able to help low-income elderly and make needed repairs. But that was a law that kind of snuck in and became effective recently. The finances for the authority is in good shape unless 101-1661 pass. It's estimated that the cost for that to us is about $50,000, and we already pay property taxes on several of our properties that were never removed from the tax rolls. CML Policy Committee acted on proposals that were submitted by cities and towns across the state for suggested legislation. We concurred with some of those, we opposed others, and some of them we will possibly address in subsequent meetings. Our next meetings are in December, February, and May. The Municipal League also held its District 3 meeting in Central City. We had reports on the impacts of all the amendments and a few other items. I was lucky enough to get reelected as Vice President of the district again. The network of care that was hosted here last Thursday, we had a total of 12 people who dropped in and out. Was not well attended, even though it was very well advertised, and I thank the staff for doing all of that, particularly Kelly. Put a lot of effort into news releases, and we didn't get very many people. So I'm going to try again at River Point on the 18th of November, and it's going to be at 10 o'clock in the morning, and we'll see if we can get a few more people at a closed facility somewhat. So,
Why don't you do Dr. Cog, too?
Dr. Cog report, the area Committee on Aging. We talked about our 4-year plan. We're meeting with Excel on the 2 tiers of electrical charges, primarily because of those people who have medical concerns like oxygen and things like that, that have to run 24 hours a day and go into that 2nd tier. It has gotten extremely expensive for some of the elderly, particularly, to pay their electrical bills. We heard from all the transportation providers in the 8 counties that are part of the Area Agency on Aging. The the Metropolitan Vision Issues Committee, we had an update on the PEIS on the I-70 corridor and policy on sustainability concerning the per capita water use, which is still going to be coming forward to the board later on. Regional Transportation Committee established a revolving fund for CDOT to use for staff work on transportation improvement projects, and we received a list of those projects that were submitted for 2012-2017. They totaled about $293.5 million. We have about $125 million to distribute, so we'll have to do some paring down on some of those projects that will be there. There was two of them that were in the Littleton area. One was an RTD project on Bellevue, and I guess that was the only one that was in this area. The Administrative Committee and the Board of Directors both meet tomorrow.
Devin?
Jim, a question on Ridge Road and the construction there. I've been getting some concerns from citizens regarding the machinery, et cetera, parking in the bike lane. When they close down for the night, they are filling up the side of the street. So bike commuters are unable to use that street. So can we...
Let me talk with Charlie, because he's had some other calls about where they're parking the machinery. Some other people who don't want the machinery parked in front of their house. So I need to talk with Charlie because we're getting some conflicting feedback from people who live along Ridge and adjacent to Ridge. But let me talk with him. We've been out there a couple of times, and it's a little bit of a tight squeeze as to where they're supposed to mobilize and park their equipment.
They aren't working on the weekends either, so the machinery is staying along the side of the road.
Okay.
I've noticed that on a Saturday and a Sunday.
Maybe they can deploy that machinery. I don't know if they have to.
Actually, if they can move it off of the street, because it is a bike lane, it is a bike thoroughfare, and it has caused a very unsafe situation for bike riders. So they can park down Ridge Road where it goes closer to Santa Fe, and there isn't any traffic because there's only two homes down there.
They can park down there on Joe's property.
We're down at the end of
So
we've had an ongoing conversation with Denver, but I'll talk to Charlie in the morning about talking with the project manager out there.
okay, then will you email me as soon as you have some confirmation on that?
Yes, ma'am.
Thank you. The other question is, Suzanne, on the ordinance we passed on low-speed vehicles, was that what it was, low-speed vehicles?
Electric?
Electric. Okay, so it is not gas-powered at all, right?
No, they were golf cars, Segways.
Do you know that they weren't gas powered?
I'm pretty sure they were all called low-speed electric vehicles.
Okay.
That's what it was called, low-speed electric vehicles. Okay, and then what was the max speed on that?
Well, you can't drive them on any road that's over 35 miles an hour.
So they can go up to 35 miles an hour. Okay.
Right, and except to cross. You could cross Broadway, you could cross Littleton Boulevard, but you can't be on those streets.
I'd be kind of surprised if very many of them get up to 35 miles an hour.
Yeah, maybe the actual electric vehicles, the ones that are coming out with the VIN numbers, those might, but not the golf cars and the Segways.
Okay, thank you. That's all I have.
Bill Gates has a souped-up Segway that goes over 35.
It's a bad idea.
It's a Shelby Segway or
Seattle, they can do that.
Bruce GT. Well, let's do a little business before pleasure here. I wanted to follow up on Steve Anderson's unscheduled public appearance. For a variety of reasons, which would potentially include maybe a lack of clarity after we had the last study session in terms of what any next steps were. our potential willingness to support developer and integrating the development ultimately with that neighborhood to a win-win perspective, and then the whole city ditch issue. I guess I'd like to take him up on his offer to see if it'd be worth having another conversation or go with them in a study session, and we'll throw that out as a motion if anyone wants to second and or vote.
Okay, it's been moved to bring Steve Anderson back for another study session. Is there a second?
Second.
Okay. Discussion. My basic feeling is he had an hour with us. I don't know what we're going to hear at the second study session that we didn't hear at the first study session. So I don't want to spend any more time on it unless there's going to be something different. And if there's something different, send us a memo. But that's my feeling on it.
From my perspective, it feels to me as though it's three issues. He's got this issue with the traffic light that he wants to talk about, and then we've got our request for easement through part of that property for city ditch, and then he's got this land swap. Those two can intermix a little bit, but at some level, I think it would be prudent for us to try to separate those. I'm not entirely certain I had any questions that weren't answered, and I felt that they spent an hour with us, and if they had something that they wanted to tell us that they didn't tell us, then I'm interested. I don't know what that could be, that it would require more time. I have a concern about hearing all of this stuff and having these meetings with these guys when there really is nothing on the table. There's not is this a situation where we're kind of trying to get a feel for whether or not we should proceed with a zoning change and start going through that process? I think that I'm not sure that that's if that's what they want to do, then go through the proper channels and start that, having little sidebar meetings or these study sessions with city council, trying to get things kind of primed and pumped. I don't know. I don't feel like I have anything that I was missing from that conversation. And he said very clearly that he would not sell us the easement unless the only way we were going to get that was to do a land swap. So I don't know what he's going to say different about that. So.
Bruce again.
Well, sorry.
Bruce again.
Go ahead.
Oh, okay. And I guess my sense is, given our desire to see something constructive done with that property, or maybe not our desire, but a desire to see that property developed in conjunction or in a positive way with the neighborhood, and given that it's been sitting out there for a long period of time, he came in and made the offer. I guess I'd like to take him up on it as in good faith, just to sort of hear them if they've got some other things they'd like to say, or if there was maybe even when they did come in, it's always, I think those those can be tough sessions just to sort of they're sitting there trying to read us, we're trying to read them. I don't think if they come back in, we're talking about necessarily more than maybe 15 minutes kind of thing. For 15 minutes or so, I'd be willing to, invest that to sort of see if there's any more information we can get out of them.
I guess part of the discussion that I'd like to see is, and I don't know if it's a study session or executive session discussion, which is what are some of the alternatives with regard to community trail or the city ditch trail that we have to deal with, as well as it seemed that there were some traffic considerations with regard to the potential of a light that were somewhat, as Deb has mentioned, issues that are separate from necessarily a land swap issue. And so there were two issues out there that I think were important. I don't know how to read the easement on the property with regard to the land, and maybe that's a third issue as well. So, as you mentioned, but
I think we're going to have to come to a decision on the city ditch, and frankly, I think getting the ditch north of the Rose Garden is pretty much not going to happen. But I think the city ditch, the alternatives for not going across that property are different than doing a land swap pursuant to anything to do with that property. And frankly, what we had in front of us last Tuesday was a piece of property that looks like it can't be developed, that already has an easement on it, at least a portion of it, that prevents it from being built on, where he wants to swap that with us to realign Bemis Road when you have 9 houses on Bemis Road from Littleton Boulevard down to Shepherd, and 2 of those are owned by him. So I don't see how swapping a piece of property that has a drainage pond on it currently so that his drainage can then be on city property for a piece of property that has value, that's flat, that can be developed, and for property that would realign a road with 9 houses on it, or 7 of them that exclude his, is anywhere close to being in the citizens' best interests. So, and him coming back, I don't see he's going to change any of that stuff. So I think we do need to have a discussion about what the likely future is of City Ditch going north of the Rose Garden, because there's issues that are beyond just Anderson's property that have something to do with that.
Well, clarify for me with that, what you just said and what Bruce said. There are some issues with the city ditch that might, or maybe Phil said this, that might require executive session rather than a public meeting because of some issues. I'm not sure. If that's so, then I would like us to go ahead and have such exec session in the near future. And if that's not so, then I'd like us to discuss alternatives related to the city ditch trail in a study session. So, I mean, is that, am I getting clear?
Yeah, I mean, I agree with Phil that we're going to need to have some further discussion on the city ditch. I think that's separate than looking at that particular piece of property and what the potential for development is and what the value is of the potential parcels. But I don't see how bringing Anderson back for another repeat of what we already had is going to fix anything.
I guess to Bruce's point, and well, I respect that. I mean, I think that, you know, I don't think shutting the door in anybody's face is a good idea, but I don't think we did, and I don't think there's nothing on the table. I mean, there's no development plans. He told me today that he has told his architect not to do anything. You know, they don't have any plans for that property. I think he would like to do something with it, but he doesn't have any plans for it. The traffic signal is, he said that's largely for the traffic that the ditch will create, and I think that then could possibly fall into a ditch issue, and I'm not sure the ditch is going to have enough traffic on it to require us to stop traffic on one of our main thoroughfares to have a few folks cross, and there's other ways to deal with that too. So we may have other issues to deal with on our own as of that, which doesn't involve him, but I'm not seeing that there's a lot on the table that we would need to talk to him about again, particularly since we already got his answer on the easement. So,
Jim?
I just think whenever a citizen comes before us and asks to meet with us, we ought to at least have the courtesy to do so. I think that you're dreaming if you think it's going to be in 15 minutes, so Bruce, I think it's going to be another hour or so session to do. And maybe there is no development plan for that project. They didn't talk about that at all the other night. They talked about needing to reroute a street in order to get people safely out of that neighborhood, and the neighborhood may buy into that. A lot of those houses that you talked about being on Bemis Street, I think some of them are businesses. I think having another study session is not going to put a big dent in our schedule. We schedule them for every Tuesday night anyway, so.
Okay, further discussion? The motion is to invite Mr. Anderson back for another study session.
The vote is 3 in favor with Councilwoman Cole, Councilman Clark, Councilwoman Brinkman, Councilman Trujillo voting no. The motion is defeated.
Okay. Pleasure?
Yeah, indeed. Let me see here. Quick reminder that the Friends of the Library and Museum International Craft Fair is going to be held this Saturday, the 23rd, noon to 4 p.m. at Bemis Library, with a vast array of homemade craft items from around the world. Proceeds benefit the poor in foreign countries. Items for sale will include jewelry, crafts from Indonesia, Egypt, Rwanda, Asia, which isn't a country, but anyway, Bulgaria, South Africa, and the Bulgarians are, that's a long-standing issue with the Friends. So let me see here. The Harvest Festival. Yeah, no, it's actually, yeah, it's if you go to any of the Friends meetings, it's the Bulgarians come up every meeting. It's great. Mr. Nims reports that the Harvest Festival set a new attendance record with 10,417 visitors, breaking the previous record of 10,254 set in 07. And then, let's see, we also set the museum's all-time attendance record, almost 132,000. And then there was about 20,500 at the craft fair, which was the second best attendance on record. So, frankly, the thing was ripping, and I think the weather was absolutely, contributory, because a couple of years ago it rained and was cold, and this year it was just glorious, which also I can report prompted about 150 former souls to come out for the second annual Littleton Zombie Crawl, wherein a good time and brains were had by all. So that was a rousing success. The Councilmember Brinkman and I have been working with Councilmember Keith Gardner over in Centennial, supporting or trying to work to support a safe routes to school program, biking program. The intent is to connect with bicycle retailers and then write letters of support and in context of supporting this as far as LPS is concerned. Councilmember Gardner from Centennial District 2 is the liaison to LPS board, and so I've had a chance to chat with him a few different times, and we've been trading some emails on that, trying to get moving forward on that one. And let's see, LPS board meeting itself, the last meeting was the 14th. Main topics of discussion were Special Services Advisory Committee year-end report, and then Gifted and Talented Advisory Council, which I think was a follow-on from the prior meeting in terms of their year-end report and proposed changes for 2010-2011, as well as ongoing support for Initiative 3A that's on the ballot for the mill levy override this fall. And in deference to Jose's fabulous District 2 extravaganza next week, which I won't steal your thunder, but I thought it was wholly appropriate then to shout out or call out the ever popular, often imitated, never duplicated Littleton Merchant Plug of the Week to a fine establishment in District 2. Actually, we'll do a twofer. You know you're hungry and you know you want one bad, and I'm talking about a gyro sandwich with a side of hummus, and you can get that at the Damascus Grill on Littleton Boulevard and Datura. And when you're done, you can either dine in or take out. But stop into, what's the name of that? Oh, I had it on the, I forgot to write it down. What's the name of that? There's a little antique store right to the north of it.
You're doing it.
I know. It's your district. It's not oh so casual. It's oh so something.
Is it also charming? Is it?
Charming. That's the word. I knew it started with a C. Oh so charming. It's right one house to the north, and it's a slick little antique shop. They do a great job. They've taken one of the houses in that neighborhood and turned it into a nice little business. So go grab yourself a gyros at Damascus Grill, and then stop into Oh So Charming. And that's
Well,
all
and another reason to stop in there, that house is so tiny, and it is a real house. It's the
Oh, yeah.
size, I think it might be a little larger than it was originally. You know that house, Jim? But anyway, it is.
Oh, it can't be
what
more
do
than
you think?
900 square foot.
I think it might be more like 6. And so to understand the size of a place somebody lived in is, but it is a very nice little place.
Jose?
Okay.
You got to plug your District 2 meeting, please.
Yeah, I guess I better. Next week, we will have the District 2 Forum here at the Littleton Center, and you have received a mailing from the city, and we'd like to see you come down and lay it on us. Whatever you got on your mind, we're ready. Thank you.
Come with your boots on, right?
The boots.
It's extravaganza, not forum.
Deb?
I move that City Council convene an exec session pursuant to CRS Section 24-6-402, Prin 4, subsection F, for a personnel matter, and it will be council and Jim Woods.
For the
And we-
review and evaluation
for
of
the-
Jim Woods.
Yeah, and we won't be returning to council
You want Jim
chambers.
Woods in there?
Tonight.
Or did you say it's about Jim Woods?
Well, council will convene without Jim Woods, and then given time,
We
we'll-
may or may not get to Jim Woods tonight.
Yeah.
bring
Given
more
what
reading
happened last
material.
time, I'm not sure what will happen.
Well, look
So,
what just happened tonight.
Second.
Bruce did. So, the motion is to go into executive session over personnel issue for evaluation of Jim Woods. It takes 5 votes. Discussion. Council ready to vote?
Vote is 6 in favor with Councilman Trio voting no. The motion's approved.
I love consistency. We will,
It's almost after 9.
we will not be conducting any regular business or any other type of business when we come back. So this will end our televised coverage for tonight.
Good night.